Megan Gray, thank you very much indeed for agreeing to discuss with us this topical issue and for your availability. We will discuss some nuances about regulating and the functioning of online search engine markets. And obviously, we understand that this market is probably one of the most important and one of the most problematic across all digital markets. So let me ask you the first question about the overall importance of this market for other digital markets. And maybe you can explain to us why it is inherently susceptible to being monopolized.
Well, I'm not sure that it's inherently subject to monopolization, but let me start with why it's important. It is information. Like, it is the foundation of human progress to understand the world around you. That is what a search engine does. You have questions, it helps you try to find the answers, to refine those questions. It is the modern day equivalent of newspapers and libraries and academic centers. And when it first began, of course, it was seen as a very democratizing force for good, because no longer did you need to rely on the nightly news to figure out what was going on, for example. And you could meet people that were not in your immediate geographic vicinity who shared your interests or concerns. And you would be able to harness all these new connections to do good in the world. But search engines in particular are that foundation of what makes the internet so wonderful, is getting information. Now, back in the day, there were many search engines, and they had different flavors, and they surfaced different answers, and their algorithms worked in different ways. And they all had their pros and cons. And then Google came around, and Google's algorithm was fantastic and so clean and simplistic. And you are not in this constant shopping mall barrage of ads and bleepy things and flashes and distractions. You were just getting information. It was a revelation, and everybody, including myself, quickly switched to using Google. And word got out, and their popularity just continued to rise. And many search engines fell by the wayside because they were not, in terms of quality, as good as Google. But there remained many varieties of search engines, particularly outside of the Western world. The shocking thing to most folks is that there are still hundreds of search engines that you have never heard of. Hundreds and hundreds of search engines. And many of them are not high quality, but you don't have to be high quality to make a good living as a search engine. And you also can cater to a certain fan base. For example, there's a search engine whose name I forget, which is targeting Trump fans. And so that's a niche market play, for example. And then you have companies like Ecosia, which caters to people who want to support green environmental causes. And then, of course, DuckDuckGo, which is very privacy centric. You have Quant, which is very appealing to Francophiles, for example. So there's still competition in the search engine market, but it is now dominated by Google. Really, it's very difficult to find market measures, but it doesn't really matter because Google is so dominant, like 95, 98%. Anything above 90, like, that's just crazy dominant.
Leaving aside non-Western markets, let's label them like this, we can see that the presence of one company is really, unbeatable, so to say. So is there anything in your view, maybe more diligent, more robust enforcement of traditional competition law mechanisms, or maybe the more enthusiastic application of ex ante rules which emerge pretty much simultaneously in most important jurisdictions, or maybe the mixture of both? What, in your view, would be able to challenge the status quo? And does the status quo have to be challenged at all?
Google started out not using anti-competitive mechanisms to become popular, but over time, they abused that dominance to violate the law. And they've violated it in a lot of different ways. So you have the Google shopping case in the EU, you have the Google Android case in the EU, you have the Google search case in by the Department of Justice in the United States, you have the ad tech lawsuit brought by the state attorney generals here in the United States. Like, I used to have a spreadsheet with all of the Google antitrust cases all around the world. And like, it is massive. You've got Korea, you've got Brazil, that Brazil just recently concluded. You had Turkey, you have Australia, it's just unending. And unfortunately, Google has created this flywheel before anybody woke up, anybody in power woke up to realize what was happening. And that flywheel meant that the runway that Google had to entrench its dominance by unlawful means and create this massive money pit to fend off any challenges by competitors and governments alike, it is almost unstoppable. Like, there is some question with a company this rich and this powerful and this so far ahead in all possible advantages, how they can be brought to heel, how they can be reined in. Vestager just this week talked about that. Notwithstanding the number of cases that she has brought against Google, like, Google is still a problem. And the enforcers are now trying to figure out how to proceed. Standard traditional laws are not working. Vestager was, I think, not just Vestager, but like the EU was smart very early on to realize a different approach was necessary. And that's why you have the digital markets, the DMA, Digital Markets Act, because that is hoping to approach this in a more ecosystem way. Because in a sense, that is how Google operates now. It's in so many different markets. It has YouTube, email, cloud, shopping, it just search, browser, mobile. It's everywhere, and it's dominant and has a monopoly in so many different markets that what happens is it's like a balloon. When you push on one part of it, it just bulges out somewhere else. And you haven't fixed the problem, because now you just have to try and tuck it in there. And it's a whack-a-mole in the worst possible way, because you haven't even whacked a single mole. And unfortunately, here in the United States, we're behind in that philosophy, in that recognition. So I am hopeful about the DMA, because I think that is one of the only ways now that tools that we have available to try to address this. But I want to take a step back. If people have not read, invested the time, and fair warning, it is a substantial amount of time, to read the UK CMA report on digital platforms, it's brilliant. The staff spent so much time and effort, and I think really got a great understanding of Google and how Google search in particular has achieved what it's achieved and how it can be addressed. The way that the UK CMA is recommending, or recommended past tense, is multifaceted. And one of the mechanisms is to require Google to provide a click and query data. So it's kind of like a pipeline of the outcome of their algorithm. The algorithm itself is not very helpful to other search engines because it has to be applied to data. And it is constantly fluctuating. So it's not just what are the most popular or credible search results on the first page, but also what people are clicking on. So it's the query, so the search results page, as well as the click stream, what people are clicking on when they have clicked back to the search results page because they were not satisfied and they wanted to check something else out. All of that data is what an emerging search engine needs in order to be able to quickly ramp up to be competitive to Google on quality. The other aspects that the UK CMA tried to address and at least recognized is that other advantages, for example, the misconception by the vast majority of people that Google is a superior search engine. I don't think that's actually demonstrably true anymore. But people still think that because they have been using Google for so long. It's got the pretty colorful colors of its logo. They use Google for email and YouTube and Chrome, and like the messaging is so, the drumbeat of positivity is so unrelenting that people have internalized this. And nowadays there are very few competitors to evaluate side by side. And most people also have forgotten how to do a side-by-side search engine comparison. So for example, with a privacy search engine, the privacy search engine is not going to have data on your past searches. So when you are searching for dog and pony, that search engine is not going to know that you are searching for the bar down the street. They think you're searching for dog, the animal, and pony, the animal. But Google does know that you're searching for the bar because you've searched for it many times in the past. And so when Google serves up as the first result, that bar, the individual thinks, oh, well, Google's a better search engine. And no, it's a different search engine. For a private search engine, you might need to put dog and pony bar.
Then the obvious question is, okay, if you are ready to, if you are a privacy savvy user and you are ready to trust the search engine who would be probably less accurate or less suggestive, then would be your choice as a mindful individuality. But from what we observe, all this appeals to privacy, to green, to the environmental issues and Amazon, planting trees in Amazon, or references to revenue sharing with publishers or end users, or even boycotting. They all sound appealing and convincing among this kind of small cluster of people who understand the nitty-gritty of this mechanics and the importance of this business. But when we scale this up, we see that it doesn't work. Precisely, I don't want to use this cliche of privacy paradox, because we know that people do care about privacy. Just as you once said in another venue, there we are too busy with all this constant, never-ending box ticking and confirmation and confirmation. So from purely commercial perspective, can you what would be the mechanism to offer an alternative, a meaningful, appealing alternative to the company which appears to exploit all the opportunities and all the vulnerabilities of end users, and offers what we actually at the end of the supply chain, what we actually want, or what we appear don't care too much about?
I don't have a great answer for that. I wish I did. I know it's not a silver bullet. I have not heard from anyone that what would be an easy solution or a quick solution. The only analysis I think that got close was that UK CMA report requiring Google to provide click and query data to any competing search engine. I think that has to be a component, because any other search engine is already going to be facing a very difficult road ahead. At a minimum, for them to say we have the same search data as Google would be a great help. And then it is up to that new search engine or other search engine to try to find some competitive leverage, which I still think is going to be very difficult, because like you say, there is a ceiling on people who are going to act on privacy concerns, know enough about privacy components to make a switch and feel good about it, or ecological aspects, or wanting to get shopping points, which is what Microsoft's Bing search engine, that's their leverage. It really comes down to the defaults in a lot of respects. And that's what the DOJ case in the United States is trying to pursue. That's the focus of that complaint. It can be very difficult in a capitalist economy to say, you cannot pay for the default. You cannot have your own search engine set as the default on your own phone, for example. We're used to other things, combating things like tying. So you cannot require Android licensees to make Google search the default. That is actually fairly easy to achieve, but Google has so many ways around that. So Google can say, okay, we won't make it a mandatory contractual term, for example. We'll just say whoever makes us the default will get $1 billion. And if DuckDuckGo or Ecosia or Bing also wants to pay $1 billion, they're free to. But of course, nobody has the same kind of money as Google. So it's not a fair fight. But it is it's very difficult to work around that from a legal perspective.
Vertical integration is one important issue, and tying and leveraging. And another one, the one which you have mentioned earlier, the opportunity to access to this sensitive and crucial information about third-party, rank inquiry, clicks, and view data. These of existential importance. We know that in the Digital Markets Act we have the provision of Article 611, which explicitly suggests that we will that online search engines, gatekeepers, will have to provide this information to third parties. But obviously, the question emerges: there is a temptation to say, okay, it's hard to challenge the status quo because of this kind of systemic and entrenched nature of this default search engine. Maybe we have to focus our scarce, limited regulatory resources just to somehow to acknowledge it as de facto public utility and impose stricter requirements vertically vis-a-vis business users and end users. But on the other hand, this would be kind of a recognition of the impossibility to introduce horizontal competition from other search engines. This is quite tempting because then it would be easier to regulate, and many, at least in the circles which I'm aware of, are more inclined towards this kind of easier and less interventionist solution, rather than trying to trigger competition horizontally and to assist newcomers, small and medium-sized search engines to enter the market or to increase their market share. What is your view on this?
So to make sure I understand, you're positing that designating Google search as a common carrier might be an easier way to address the monopoly in the market?
I refer to this kind of metamorphosis which we observe, where the gatekeepers in general are getting so powerful that they can somehow acknowledge and process all the societal concerns vertically by basically saying, okay, do you want us to remedy this and this? For example, privacy would be the most appealing, most convincing, in my view, example, where you can use privacy as a shield and as a sword. And now we can say that Google can easily say, okay, you care about privacy. We are happy to design the system where you will not be stalked anymore by small and medium-sized advertisers, and we will somehow disintermediate you from each other, and we will process this information and provide you with accurate results. You trust one company rather than 1,000 different companies. From the perspective of purely privacy, sensu stricto activism, this sounds like a appealing solution, but this would only reinforce the status quo and make any competition on search engine market or browsing market even less plausible.
If you walk into this this very fragile perspective that if you trust me, I'm Google, if you trust me, I want you to trust me, and I will protect your privacy, and I will do a very good job of it because I've got billions of dollars to protect against hackers and have all sorts of technological features that will do two-factor authentication for when you're accessing your Gmail and, prevent intrusions. And I will do all of these things to protect your privacy from other people. I'm not making any protections for your privacy vis-a-vis you and me. I, Google, can exploit you and your data and your activity as much as I think is helpful to me. I'll put certain guardrails on it. I promise I will not use it in an sextortion scheme against you, for example. But I will use it to show you certain images that my database indicates trigger purchasing behavior by you, for example. I will manipulate you in some innocuous but a subconscious way to influence your online behavior. And I will be the only company that will have these insights into you and other people like you. Therefore, all advertisers will have to do business with me because they would like to know those triggers. And I will facilitate showing ads, for example, to you during those trigger moments, right? And all of this just builds Google up richer and richer and richer. And we as a society become more and more and more dependent on Google. And I am absolutely confident that Google as a force for good will not always be there, because absolute power corrupts absolutely. And when there are no other viable competitors in the market, and we are pretty damn close to that right now, with a 95+% market share in the search engine market going to Google, then we will have no other sources for information. We will not have choices on how we want to protect our privacy moving forward. It's already very difficult. I, for example, am a longtime privacy advocate, but I have kids now, and my kids go to public schools, and they are required to have Gmail accounts. And I have to email with my children. I can't stay off the Gmail system, you know, and that's like, there's just no way to stay out of that, to you know, try to live certain values.
Okay, we have explored quite a long list of possible ways to somehow to mitigate the systemic presence and omnipotence of the default search engine, such as sharing the mandatory access to sensitive data, or the important, the crucial data for newcomers or smaller competitors who want to increase their market share. So this would be option one. Obviously, browser competition and the issues of pre-installation menu. We have some improvements in this front as well. Some authors suggest even the mechanism of pre-installation lottery. So these are somehow, these appear to be within the toolkit of regulators on the kind of Western side of the world. Just if we look further at more authoritarian jurisdictions, they are much more persistent and by being ipso facto authoritarian. Some just prohibit Google from gaining the momentum and being just blatantly protectionistic, essentially creating their own search engines, which again show similar systemic features as well. Others are more sophisticated or Machiavellian in this approach. They just require mandatory presence of domestic apps on the App Store, or maybe some X percentage of alternative search engines being pre-installed on manufacturer website, on manufacturer's menu and operating systems. These steps are way to regulate, to authoritarian and too interventionist, of course. Should we be at least aware of their presence? Should we monitor the space, or is it kind of taboo ipso facto, which shouldn't be even raised in kind of more humane liberal societies?
I think it is always good to understand different approaches, but I think it only goes so far. And I don't know that it's all that necessary. because we have done this in the Western world. We haven't done it for a while. Our muscles are atrophied. We're not used to it. It's highly politicized now, but we have, even in the United States, and certainly in the UK and in Europe, examples of being much more interventionist in the market. So it's not a great example, but it is one example, which is the Microsoft Internet Explorer browser case, which both the EU and the US pursued as an unlawful monopoly. And the most important lesson from that case in the United States was how interventionist the remedy was. It was a settlement, mind you, not a verdict from a judge. But in that settlement, Microsoft had to pay and provide full-time offices to an entire department that had to review and approve or reject almost every business decision by Microsoft, down to the nitty-gritty, the messaging, the marketing for the browser, the bigger picture issues about defaults and embeds. Every aspect of Microsoft's involvement in offering or providing or mandating the browser. And you know what? That impacted Microsoft's behavior. Brad Smith, the current top executive, lived through those days, and he will be the first to tell you that that was a hellscape to live through, to have these bureaucrats have to demand to approve in advance almost every business decision of that that component of Microsoft. And it is the reason why Microsoft claims that they lost out on mobile, why they missed the boat. And you can disagree about whether or not that was good or bad, but you know what? It opened up a world of competition for Google. And so if you take the same approach with Google now, I'm confident that something will happen. There will be a new innovation where somebody else will be able to jump quicker than Google, because Google will be tied down with all sorts of administrative, bureaucratic, government interventionist red tape. And particularly in search, you can imagine many ways to implement this. You can have the API of the click and query. You can have prohibition on default settings. You can have pre-approval of the bogus, scary marketing messages that Google is constantly pushing out about how you're not safe unless you have Chrome as your browser, which is a browser, but is inextricably tied to search because, of course, as Google's own browser, Google search is the default. So you have to get very enmeshed into many aspects of Google's business. Email, for example, Gmail constantly has levers that it's pushing so that you're using Google search rather than another search engine. So you can imagine a world similar to what we had in the United States with Microsoft, where you are really in Google's business and slowing them down and preventing them from playing the games that it currently plays. It's just something we haven't done in a long time, and it is expensive, and uncertain, because if Google does not agree to it in a settlement, it is very difficult nowadays under the current political landscape to imagine at least a judge in the United States mandating that. It's not impossible, but it's a long shot, and it certainly would not happen anytime soon because of the whole appellate process. That's why Europe's DMA is probably the best hope right now, because the DMA, at least on paper, envisions this kind of in the weeds, detailed determination and decision-making process by the government on how gatekeepers like Google conduct their business in great detail. And the challenge is hiring those people and ensuring that the gatekeepers are paying for those people, because it's going to be a constant battle with Google and other gatekeepers playing games and withholding information and misleading them and sending them on wild goose chases. And you're going to have a massive commitment of people and tech savvy to continue nipping at Google's heels and not go away. And the DMA, and correct me if I'm wrong, but the DMA does provide a financial mechanism for Google to pay for that. So hopefully that actually happens, because otherwise Google is going to bleed the government dry before anything is actually accomplished.
And if you look at these potential challengers, do you think the most plausible, those who would benefit from this kind of more regulatory approach, constraining approach, do you think those would be the present search engines, or they are still in the infancy stage, in startup stage, sitting in their virtual garages somewhere?
I don't know. We already have a couple of new entrants that are exciting and have new ways to try to differentiate their business model. You.com, YOU.com is one. You've got Brave Search. You've got Neva. And there's a couple more that I've heard of, right? So who knows? You could see Microsoft deciding to invest money in real money in Bing, maybe make that like a preferred choice. You've got DuckDuckGo, you've got Ecosia. There's all sorts of companies currently in existence who could make a dent. But there's also, with any luck, going to be companies that we haven't heard of yet. Because if Neva or DuckDuckGo, whoever is starting to make a dent, that's how capitalism works. Then you get more companies trying to chase that, that outcome, that success. So great. Like the more the merrier, as far as I'm concerned.
Then an obvious concern would be about those kind of hyperscalers who would come from other jurisdictions. How is there any mechanism to not to allow them to scale up in EU and US? Should it be a problem at all?
That is the question being grappled with right now with CISPS and TikTok, the national security aspects in the United States of TikTok taking up so much time and gathering so much personal information and potentially being in a spot to manipulate Americans, right? That somehow it should be regulated, which is very difficult to accomplish in the United States, just by nature of the kind of free and open expression and consumption of entertainment. And I'm not even going to try to address that right now. Instinctively, I'm not a fan of trying to say, no, you're from a search engine from Japan. We don't want you to dominate here, because then we don't know what, maybe you create an alliance with I don't know, India, and we're at a disadvantage. Like, I just think that becomes untenable in a way. If you're concerned about the national security implications, for example, then there's other mechanisms to address that, as opposed to saying, no, you are a certain kind of company from a certain kind of country. We don't want you to succeed. I think that's even more difficult nowadays, because increasingly it is difficult to say that a company is French or Russian or whatever, because they often are global companies with employees and staff and technology that's spread out all over the world.
If there is something off the top of your head which you could recommend to young law student as a topic of, let's say, dissertation or maybe even PhD research, what it would be?
Oh boy, I have a lot of ideas. I would love to read an in-depth study of how the UK CMA was able to successfully jump into a very complex, nuanced issue like the Google digital platform and understand it so quickly. How do we replicate that? How does the EU with DMA, for example, accomplish that? All I have heard is, we're going to hire some people, and some of them are going to be technologists. Well, for the EU to be successful with the DMA, we need to have a lot more than those vague hand-wavy things. Like, does it require 400 people? What kind of technologists? Like, what is it that made that UK CMA digital platforms report successful? Was it a single person who was just a bulldog and wouldn't give up? Like, what was it? Was it certain subpoena powers? Was it the collaboration of economists with litigators, with bureaucrats, with, like, what was the secret sauce? Because the EU will need to replicate that. And what I'm seeing so far, the EU doesn't have a clue. Like, saying we're going to hire technologists is very scary. It's like saying, I'm having heart palpitations, I'm going to see some kind of doctor. Well, are you going to see an eye doctor? Are you going to see a cardiologist? Like, there's also lots of different kinds of cardiologists, and it's really important to get the right one. Like, you need to think harder about what you need here to be successful. So that's one. I would love to see kind of that comparative analysis of the UK CMA, the EU, and the FTC, because the FTC is also total failure in connection with understanding this technology markets in the same capacity that the CMA did. So that's one. The next one is transparency, because what you and I will be able to point out and help with and explain the bullshit and games that Google is playing in whatever field, like, we need to have some information that the regulators have, because they're not going to know, because they're not in the market. They're not market participants. It's very hard for them to realize, oh, this itsy bitsy change in word phrasing actually makes a huge difference in our world. They won't know that. So how can we have a system where the enforcers get Google's confidential business information and make enough of it public that outside stakeholders can try to assist? So the interesting aspect of that is with a lot of the US state privacy laws that are coming into effect right now. They are not coming into effect right now, but recently enacted. They have requirements for certain types of transparency reports, and they're all slightly different. And here's the key. Every state has different laws on whether or not those transparency reports are made public. And I have not seen anybody get into that analysis of, okay, the best transparency reports that will be accessible to us is from Colorado, or they're not accessible to us anywhere. We need to be advocating for a sunshine law in Virginia, right? Because that's a little, tangent to a lot of the kind of privacy and competition discussions, but incredibly important. And then the final one, it really is the final one, is global opt-out. Global opt-out, a do not track for online surveillance, has great promise, and it hasn't happened yet. There's going to be a lot of challenges. There's one in California. There's going to be a lot of legal challenges with that because it was not enacted well. And I started a Twitter thread on this a while ago because I was hoping somebody would write this up. Colorado has a global opt-out. Another state has a global opt-out. California has a global opt-out. I think there's one with the DMA, maybe, certainly with aspects of GDPR. And I would like to get them all in a big spreadsheet to explain exactly the features, technically and otherwise, for each of them, and how they're implemented, and see how we can improve on that, because there will be another privacy law somewhere, maybe a US state, maybe in Europe. And if we can get that global opt-out control done right, that's a game changer. Because then if you can really have an effective global opt-out, you have just cut the knees out from Google, their entire business model. So all of the difficulties that we're facing right now with enforcement under the DMA, with the competition cases, with the privacy conundrum, if you can have an easy mechanism that automatically gets rid of the Google surveillance, Google itself will have to make some changes that benefit all of us.
Well, if some of our viewers would eventually come up with the decision to write on any of those three topics, please don't forget to drop a line to Megan to say thank you for these helpful and really promising recommendations. Megan, thank you very much indeed for finding time and for discussing these topics with us. It was a pleasure talking to you, and my most sincere gratitude.
Thank you very much.